Yeah, welcome to the PPM Attorney Capital Forum. Just a little bit late getting started. I just connected. I'm here in Prague tonight. It's actually, I think, is it 2 p.m. or 4 p.m.? Actually, I think it's 5 p.m. on the East Coast. Yeah, 5 p.m. Eastern Time, 3 p.m. Mountain Time, 10 p.m. here in Prague. Um, just here on a little vacation with my wife, and but we wanted to stay on target on the PPM Attorney Capital Forum. I'm shooting from outside. I don't know if you can see the skyline of Prague at night. Beautiful city. Can barely see that in the background. The Prague Castle, and we just got a little Airbnb here. So the lighting here is not the best out here on the balcony, but the weather is perfect, so we might as well get started. So thank you for tuning in, and we are going to be talking about the PPM, the essential elements of a private placement memorandum. And some of you have already submitted some questions, and I'll be covering those at the end of my monologue here. But if you have other questions that pop up during the course of the event, we'll try to address those. If we don't get to them in the live stream here, you can always email. You can always email me directly at darin@mangumlaw.net, or you can send a message to Colby at mangumlaw.net, and we will look to address that. Or you can just send a general email to info@mangumlaw.net, and we'll be able to either answer those directly, or we can certainly cover them on a future forum session. So this is a forum session number 5, Essential Elements of a Private Placement Memorandum. We talk all about private placement memorandums, PPMs. Before we get into the mechanics of a PPM, I mean, many of you may have already seen a PPM. Some of you have not. I mean, sometimes you see bad examples of PPM, something that says private placement memorandum on it, and sometimes I get those to review. Like we often get them to review from either an attorney that may not know what they're doing, or somebody that may have found some template online. Sometimes they sometimes they hit close to the mark, but oftentimes there may be a compilation of many things. Many times, a lot of private place memorandums, like a template that you get out there, they're written mainly from a marketing perspective, trying to wow the investor through some really nice presentation, like a business plan. And so sometimes people will take like a business plan, and then they'll just tack private placement memorandum on the front of it, and they'll put some legal disclaimers. Hey, this is not an offer to sell securities, or there's risk involved, and then they'll just throw out a business plan. A true private placement memorandum has a specific format. There are certain criteria that are required, that are deemed what we call material by federal and state securities regulators, number one, and number two, by the law as interpreted by the courts. Okay, so those are things that have been delineated over time as to what is considered "quote unquote" material information, meaning is it the type of information that an investor would deem important before making an investment decision. And that is, there are certain levels of disclosure that need to be met in order to rise to that level of full disclosure. You can't just get away with putting together, hey, here's my idea, and here's what I'm going to do with the money, and that's it, right? So we can talk about really the purpose of the PPM is to satisfy federal and state securities law disclosure obligations, which really is your the PPM is your ticket, your get out of jail ticket. Okay. And it's possibly a dismissal of the case ticket, okay, if you ever got sued, okay. Two ways this comes up. Certainly, if you're utilizing a private placement memorandum, then usually so in order to incur liability under the securities laws, there's potentially civil liability, and then there's also potentially criminal liability, right? Certainly, criminal liability is the worst of it, right? And I can tell you that if you're not using a private placement memorandum, then now the SEC may not come after you because SEC only has civil authority, but all the state securities regulators, all of them have both criminal and civil authority, right, to bring a case against an infraction. A lot of times, state securities enforcement attorneys are what we call deputized by the state attorney general, and they can also bring criminal charges, right, in addition to civil, right. So we've had situations where clients that raised capital, and if it's a significant amount of money and there really is no good explanation as to where it went, and there is no PPM, then chances are you're probably going to be looking at a criminal investigation, right? They're just going to assume the worst, and hopefully you can hear me on this. If you're not able to hear me, if you could message us as well. I didn't bring my microphone on this trip, but hopefully you can hear me. But essentially, with a private placement memorandum, you're deemed to be. The presumption is that maybe you didn't have criminal intent, but maybe there's still, if the PPM isn't sufficient enough, or if you don't, then maybe they'll look at just civil penalties, right? Civil liability, right? But obviously, if you have a full PPM and you did what you're supposed to do with the money, and all the material information is there, like we'll cover today, then oftentimes the case will get dismissed for failure to state a claim. Especially if you put on, I've seen it happen where the defense counsel uses it as a tool to build the defense, and they are able to get the case dismissed because of the full disclosure, right? And so that in those ways, it's both a get out of jail card and or a ticket. Probably a get out of jail card like Monopoly, right? Get out of get out of jail, go straight to go, collect $200, whatever. It's not that good, but it's certainly better than getting stuck in jail, and it's certainly better than having a case that is languishing in court, right? And so typically the way, and we'll go through these elements, but usually defense counsel will use the PPM to walk the investor through the document, because ultimately, if it's done properly, if you have a signed subscription agreement and the PPM was actually delivered to the investor, which are important, if those things occurred, then the defense counsel will walk the investor through the document page by page, sometimes ad nauseum, over and over again, and make the investor acknowledge that yes, indeed, they received the PPM, and isn't it true that this was disclosed here on this page? Can you please read that for me, Mr. Investor or Mrs. Investor? And they read it, and then they say, what is your understanding of that? oh, well, my understanding of that is that this disclosed risk, and isn't it true that you agreed to this? Blah 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 blah, right? And if they say no, I didn't really agree to this, then they take them back to the end where they say, oh, here's your subscription agreement, and what does it say right there? It says that you receive the PPM. It's not this your signature? Is not this your initial saying that you acknowledge and receive the PPM and that you agreed to accept these risks? And they say, well, yeah, I guess that is my signature. And so basically it's like, well, which version are we supposed to believe? That what you're saying to us now or what you were saying to us back then? Because it's obviously in conflict. And the person says, well, I guess I did agree to it. And then they go back to other elements of the document of the PPM. And usually if you see it play out in court, that's you could get on, you have the investor on the stand for at least an hour, several hours possibly, and just walking them through point by point by point where this was in fact disclosed, and the fact that they agreed to accept these risks, and the fact that, look, nobody did anything nefarious or illegal with the money. And so that's how the PPM is utilized, right? So oftentimes people ask, well, why is it so redundant? Sometimes it says some of the same things over and over and over again. Well, it's redundant by design because it certainly goes through and because you're going to be walking that investor potentially through the entire document. It says it not only once, but it says it twice. It says it maybe 3 times, over and over again. It's not just like embedded in one section of the document. Maybe it says it several times throughout the document, and that redundancy helps kind of really reinforces the point that, hey, this was in fact disclosed to you, and yes, not only do you agree to it once, but you agreed to it every time that it appeared in the document, that you sort of assented or agreed to it, and that hard for the investor to come back later and say they didn't know or they weren't disclosed this or that and the other, right? So anyway, we can. And if you wanted to, if you for members of the forum, if you ever ask, we could certainly send you a Dropbox folder that has several dozen example PPMs of different kinds. We have real estate PPMs, we have oil and gas, we have pharmaceutical, we have real estate syndication, just different types of PPMs that go over. That we could show you as examples. Could you like copy them and use them? Yeah, potentially, right, if you really wanted to, but I wouldn't advise it because those PPMs are designed specifically for those particular clients and those specific deals. And so whenever you go and take 120 page document and you try to copy it and hope for the best, well, you do so at your own risk, right? But the whole idea of sharing that is just to show you, hey, here's what the PPM substantially looks like, and we can dive into what that is. Usually, you'll have basic, kind of boilerplate disclosure in the very beginning. The cover the PPM basically has the date on it and the name of the issuer, and it summarizes the deal. You'll have general SEC required disclosures, and then you'll have state specific disclosures even before you get to the title page. And so that's all, probably kind of like the preamble for the PPM. And most people just skip right over that. You certainly want to have a fresh current date on the cover of the PPM if you can. The PPM should be current. If you're using a PPM that's like more than, I'd say 6 months old or longer, then sometimes investors look at that and think, well, maybe this PPM isn't the latest and greatest information, and so you want to like keep it up to date. Certainly, if the PPM is older than 1 year, then you're going to want to update that PPM, right? So, yeah. So anyway, so usually when you'll get to what we call the executive summary, which is really just to highlight the very key. The purpose of an executive summary is not really just to. It's not really to. It's really to give a high-level overview of what is in the document, so that an investor can quickly discern. I mean, we still use executive summaries, even though for the most part, a lot of people will use a pitch deck, like a slide deck, with pictures and color and different basic information that highlight the deal terms. But we still use an executive summary because some people don't use a pitch deck. They just utilize the executive summary as a pitch deck. You could certainly usually executive summary is only a couple pages, maybe 3 or 4 pages, that just really hit the highlights of the deal, and that way the investor can get a sense of what is in the document before they read the rest of it, and basically supposed to capture the investor's attention. Obviously, if they don't like what's in the executive summary, they're probably not going to read the rest of it. Yeah, that's really the whole point of the executive summary. Is a high-level overview of just the key points of the document. Usually, right after I've in the outline here, the forum outline, I've got company overview and business plan. Usually, that's set toward the middle of the document. Usually, right after the executive summary, we get right into risk disclosure, and that we found that's a better place to put it, and not because of any hard fast rule, but because oftentimes SEC, well, for public filings, usually risk factors is stated right up front. And so we decide to, in a private placement memorandum, to follow that same format, put risk disclosures right up front. It's not to say that if you did put your business plan right after the executive summary, that's a material mistake. That's not necessarily the case, but I think it's best practices to put those risk factors in right after that executive summary, because you're basically saying, hey, look, I didn't like try to get you all whipped up and excited about the deal and then later give you risk disclosures. No, I gave you the risk disclosures right up front, and if the risk factors scare you away, then there's no need to read any further. Now, a lot of investors, they'll take risk factors with a grain of salt. A lot of them are very, very specific. Or I'm sorry, they should be most of the time they're really general in scope. Like if you have a if you have a real estate project, most of those risk factors are going to be pretty general as to risk related to real estate in general. There are specific, you want to be as specific as possible. You want to cover as broad a range of risks as is potentially foreseeable with given the type of investment. Like if it's oil and gas, it's going to be very specific risk factors related to oil and gas. You're going to have general risk factors that would be applicable to any company or any venture or any fund, but securities regulators, they're going to certainly look to, hey, did you provide industry level specific risk disclosures as to this particular venture, this particular deal, and also maybe this particular company, right? Because there may be additional risk factors that are associated not just with the industry in general in this space, but with your particular venture or your particular property, right? If there's like, hey, we're we're building on swampland, right? There's a potential that there's additional risks that are associated with, like in Florida, right? You're building on, you know, this limestone that may have sinkholes, right? That's a potential problem that maybe a piece of real estate in Oklahoma wouldn't have, but maybe the one in Oklahoma, it's got tornado. It's like in Tornado Alley, right? And there's a tornado every year that comes right through there. Okay, that's a specific risk factor that's related to that property that may not be applicable to Florida, right? And so you want to definitely take, if it's in a flood zone or if it's in, and so I mean that's real estate examples, but certainly when it comes to, like oil and gas, right? Oh, if there's risk associated with blowouts, or there's risk associated with, all kinds of different specific factors that aren't. Yeah, you definitely don't want to take a PPM that's written for real estate and try to apply it to oil and gas, or like you have a pharmaceutical company, let's say, like a pharmaceutical company, those have specific industry risks, regulatory risks, product liability risks, and not just pharmaceutical companies, but any sort of product, consumer type product. You may have specific risk factors that are associated with that need to be addressed, right? So that's why that's super important. And again, I know in the outline we have it in a little further down, but we always like to put those right up front in the document, and those are certainly important. If the SEC ever looked at it, they're going to want to see that in there, and especially if you ever had any potential. Again, if you were, like we were talking about earlier, if you ever in a litigation context where an investor was suing and you had the investor on the stand, or you're deposing them and you're going through the PPM, you want to hit those risk factors right up front. And that way, it's going to take a lot of wind out of their sails when you go through all those points and you say, hey, isn't it true that you read, you received the PPM. I know you're saying you didn't read it, but you say you accepted the risks. And in fact, here it says you did read it, and here's these risk factors, and let's just walk through them. And you're saying that you weren't disclosed that this property was, potentially subject to a hurricane or anything like that. Well, let's go to page 29, where it talks about risk factors related to, weather, acts of God, different weather events, blah blah blah. Right? Those are potentially within the scope of possibility that was disclosed to you, and so you can't now sit here and say that you didn't know that, right? And so that's how that's used in that context. Certainly there's other risk factors related to. Typically, we cover general risk factors. We talk about industry specific risk factors. We talk about company specific or deal specific, maybe property specific risk factors, right? And then we'll talk about tax risks. If the PPM is drafted to be made available to like retirement accounts, retirement plans, there's risk factors that go along with that. And then of course you get into, after you've covered all that ground, then you would get into the company overview and the business plan, which gives kind of an overview. Hey, this is our strategy. This is what the company is all about, and outlining not only the company business plan, but here's the management team and all that. And so that doesn't really appear until the middle of the document. And you'd think it would come right up front, but again, the presumption is that they've received a lot of that sort of positive information already anyway about the company. Otherwise, you probably wouldn't be having this conversation with them. But certainly. But you obviously need to cover, hey, this is the information about the company, and this is what we plan to do with the money. this is what our growth strategy is. This is why we're raising capital, right? And you lay that out there in the PPM. Sometimes that's pretty short and simple, and sometimes that's more intricate and involved, especially if it's a technology company. And how not only what is your idea and what is your plan to how are you going to use the money, but also what are you going to be doing? Why, maybe what is your growth strategy? What is your your growth model and all of that? And a lot of that's obviously based on presumptions that we'll have a general just kind of a general outline of, hey, this is all forward-looking statements, and all of that is potentially subject. This is all contingent upon the risk factors in the PPM, right? And so that's something that is part of that business plan section. Usually you will have part of that business plan will have, hey, if you're raising 5 million, if you're raising 10 million, what do you really plan to, what are you really planning to do with that? If you don't have that specifically outlined, you can certainly have just hey, we're using it for working capital, toward these general objectives. You may not have that detailed out specifically, and I think you definitely want to keep that as broad as possible to give yourself flexibility. You don't want to say, hey, we're going to use it for this, and nothing else, and not have any contingencies built in. You definitely want to give yourself some wiggle room as to the dollar amount or the percentage allocations. Some more professional investors may try to nail you down more specifically as to that and say, hey, look, you can't use this money for anything else. But generally speaking, you want to you're the one that's setting the terms of this PPM, and so you're going to give yourself some flexibility as to the use of proceeds, right? And so anyway, that's certainly an important section. And then, of course, obviously, you're going to get into the investment terms and the terms of the offering. What are you offering? Are you offering common stock? Are you offering, voting rights? What's the sharing arrangement? If you're doing a private fund, if you're doing a sharing arrangement of some kind, that's obviously detailed. It's detailed a couple different places. Obviously, it's usually detailed in the executive summary. Hey, here are the specific deal terms. It's usually explained in more detail in the body of the PPM as well. In that describing the actual securities that are being offered. What are the terms? Is it debt? Is it an investment contract? Like we were talking about a few weeks ago, the different types of securities. Certainly that's explained. Or if it's equity, are there voting rights? That's explained in the PPM, and it's also usually explained in the exhibit section if you're attaching, say, an operating agreement for an LLC, or if you're attaching a bylaws, or you're attaching a limited partnership agreement in the case of a limited partnership. It's also going to be detailed in those documents as well. But here you're explaining those deal terms, and it is important to make sure all that's consistent, right? You want that to be consistently presented throughout the executive summary, throughout the body of the PPM, and throughout the operating agreement or the bylaws or whatever type of entity that you are, right? And so that's obviously that's the meat and potatoes. These are the securities that we're offering you, and so that's important. So they've received risk factors. They've received the business plan. This is what we're going to do, and here are the deal terms for the securities themselves. One important Also another important part is, the management team and personnel section. Usually one of the first things we ask for is like, hey, we need bios for all the management team. And they're like, why do you need bios? Well, it's deemed material information to know who is running the show, right? Who's making investment decisions, who is, who's going to be dictating or who's going to be in control of the money. And so, if you're just a one-man show or one-person show, one-woman, show, then that's where your bio would be as the CEO or the general or the managing partner or whatever structure you're doing. And people want to know your, what kind of background do you have? What is your educational background? What is your work experience? What's relevant information to let them know? Hey, I've got some business experience to run this company or to run this private fund or whatever. Now, you may not have that experience. You may not, this may be your first rodeo and you just have a great idea and it's not something that you've done before. And that's okay. But again, it's just disclose, hey, I don't have any experience doing this, but now you're probably going to have a hard time raising money because investors are like, well, I don't know if I want to trust you with my money if you've never done this before. And so oftentimes it's a smart idea to surround yourself with other team members, and they don't necessarily have to be co-owners with you or full partners with you, but you can certainly, put together a team of experienced personnel. Maybe they're consultants, maybe they're all consultants, advisors, either other people that may be willing to act as your board of advisors. Again, they don't necessarily have to be have executive authority, and they don't necessarily have to be owners of the company, but maybe they're agreeing to be advisors to you. And okay, well, you're going to include those people as advisors in the PPM. Obviously, get their permission to do so, but if they're willing to do that, then that just makes your management team look way stronger, and you can certainly use their information not only in the PPM but in the pitch deck as well. Again, you want to make sure you adequately disclose their position. You don't want to call them, oh yeah, this guy's my, I got Warren Buffett as my CFO, right? When in reality, Warren Buffett just said, hey, I'll be on your board of advisors. You don't want to misrepresent there as well, right? And it's also important to make sure your bio is not, some people's bio information, like if you look at their LinkedIn profile, sometimes it's a little overblown. It's overstated. It's a little bit, there's a lot of puffing going on. There's and that's okay, but as long as it's materially correct, you don't want to, say something that's not true, right? And so sometimes that's sort of a Achilles heel, is that some people, they'll overstate their qualifications. Yeah, I ran $1 billion company and I'm responsible for all this success. And then in reality, maybe it was a little bit overstated, right? And that may be something that may come back and haunt you, right? So you want to make sure that the information you consider in your management team is both is materially correct, right? Not overstated. Financial information. Now, this is a place where I see a lot of people get in, even PPMs. We've reviewed PPMs drafted by other attorneys, and they'll make the mistake of just slapping a financial, what they say. Oh, here's financial statements, when in reality they're financial projections, right? You do not want to use a financial pro forma in a PPM. I've seen it time and time again, and it comes back to haunt people, because pro formas are pro formas are always, it's like the weather, it's like a weather forecast, right? It's always going to be wrong to some extent. And what you don't want is to say, what you don't want is for an investor to say, oh, I invested based upon this financial pro forma, and the pro forma turned out not to be accurate and true, and therefore you've defrauded me, right? What you do want to provide is current financial information, which in a lot of cases it's like maybe it's a startup company, maybe it's a brand new fund, and those numbers are pretty minimal. It's like a zero, right? It's like zero. Like, hey, it's a brand new fund. There is no assets. Now, do you still want to use a financial projection? Yes, but not inside a PPM. It's okay to use a financial forecast in, say, like a pitch deck. Like or usually as a standalone financial forecast, and say, hey, this is a financial forecast, and as long as it has disclaimers on it saying, hey, this is based upon a lot of hypothetical assumptions that may or may not occur, and that it's qualified in its entirety by the PPM. Go read the PPM, because the PPM is going to tell you, hey, it's not going to tell you, it's not going to make all these grandiose claims of future profits. It's going to say, hey, this is the material information that is current as of today, as of the date on the cover of the PPM. And so you definitely, your financial statements are going to be whatever your most current financial statements are. If you have audited financial statements, definitely use those. If you don't, there are exceptions to the requirement for financial statements. It really depends. We can do a whole session on financial statements in another session, but essentially, if as long as your financial statements are materially correct as of the date of that's on them, then typically you're going to be fine. Now, obviously, there are certain exemptions and certain regulations that require you to use either reviewed financial statements or audited financial statements, but we can get into that another time. But you definitely want to include them. Sometimes I've had clients say, well, I don't want to include a financial statement because it doesn't look good. And it's like, well, they're not really investing in you based on what you look like today. They're investing in what you potentially are going to be doing. And so you still have to provide them with that basic financial disclosure so they know what they're getting into. At the same time, you can still paint a rosy picture, potentially a rosy picture for the future, and entice them based on that. But ultimately, you're qualifying all that positive future potential with what is the current state of the company or the venture, and that usually obviously if you have current revenues, yeah, you can show that, but you definitely want to provide historical and oftentimes it's a brand new entity, so it's just going to be basically, hey, we just opened a bank account and here it is, and this is just, we're just starting out here. So there is no, oftentimes there is no assets in the company to start, right? Now you as a founder may have put in some capital and put in some assets. Well, that all should be reflected in the PPM or in the financial statement of the PPM. Let's see. It's okay. We've talked about all these elements, legal considerations. Yeah. So there are also other elements of the PPM that you want to cover. We could talk about bad actor exclusions. I think I'm going to cover that more in detail on another session. But essentially, if there's any past and material past financial related securities transaction, whether it's securities infractions or financial infractions. When I say infractions, I mean, was there any legal proceedings that may be deemed material by an investor that may have occurred in the past, and that those kinds of things should be disclosed. I think I'm going to grab some water real quick. 1 second. Okay. Sorry about that. Just had to get some water here. That's better. Also, some things that would need to be disclosed if there's conflicts of interest that are associated with the deal. If you have if there's sometimes you may be acquiring assets that are acquiring assets that may be owned by an affiliate company that maybe you own, or people that are also involved in the deal own. You definitely want to make those disclosures. And then also, as far as any kind of material past proceedings, like if it's like maybe a bankruptcy that may have occurred in the past, or certainly if it's a security, if you had a securities violation in the past, you definitely want to include that. And obviously, if you have certain securities infractions that may have occurred in the past prior to September of 2013, or since or after September of 2013, then you would need to, you would potentially be excluded from relying upon certain safe harbor exemptions like Regulation D. But we can get into that in more detail. But anyway, so certainly you want to disclose those kinds of things. Sometimes these things are not they're not dispositive, or they're not they're not going to prevent you from raising capital. But in some cases, if you have a bad enough history, that there may be there may be certain other strategies that we need to employ in order to legally be compliant, right? So anyway, but that's all stuff you can dive into the weeds on, and making sure that our job, of course, as lawyers, is to make sure it's 100% legal. And so but we definitely want to make sure that anything that may have happened in the past is disclosed, and also it again may dictate what exemptions and what path, legal regulatory strategy we recommend, right? So certainly one of the key things is obviously just describing how to actually subscribe. You have typically a subscription documents. You'll want to outline what how to invest, right? And so after all the PPM is, all the disclosures have been made and delivered to the investor, certainly you want to outline what is the process to actually invest, right? And step them through that process. Usually you give them a little checklist. Hey, you need to fill out the subscription agreement or the suitability questionnaire. And then you also need to fill out the subscription agreement, explain how that's done, and then obviously, provide them with those documents so that they can invest, right? That's part of the process, right? That's where the rubber hits the road, right? And where they actually decide, okay, after going through this entire document, now I'm ready. I'm still willing and interested in investing, and here I can fill out that paperwork. And certainly it's important to make sure you keep good records of the suitability questionnaire, and also your subscription agreement. Make sure for every investor you have, you keep a file with those, with those documents in there. Obviously, with any correspondence that you have with those investors, you want to make sure you keep good records. And Anyway, but that's sort of the the that's an important element of a PPM as well. Hey, how do I actually, now that I've received the PPM, how do I invest? That needs to be clearly laid out as well. Um, so yeah, those are all the what we would consider key elements of the PPM that you'd want to make sure are in your PPM, and those are things that we of course help with. Um, we have um, we have I think we have time for maybe one question here. One question is here. Colby is asking, what is the what do you do if you have a past securities violation? Does that exclude you from from raising capital? Now that's a great question. It really depends on the scope, right? It depends on the scope um, of that infraction. Oftentimes, people, unless they're really, really bad, we call bad boys or bad people, um, that have multiple securities infractions. I mean, usually it's kind of like a three strikes, you're out sort of idea, right? It's like, look, if you've had one, two, three run-ins with the law when it comes to offering securities, and you've come out on the wrong end of it every single time, yeah, you're probably likely you're gonna maybe the sanction that was imposed upon you. Well, yeah, ultimately, they could throw you in jail, right? But but oftentimes it may be a civil penalty, or sometimes they'll try to settle these type of you know multiple offender type situations with, hey, you're going to basically consent for us to get rid of this. You're just never going to raise capital again. That's kind of an extreme position, but most of the time, people that run into securities problems in the past, they may get a cease and desist, you know, or they'll something like that, and that doesn't that may exclude them from relying upon certain exemptions, but it doesn't necessarily say that doesn't mean that they can't raise capital under any circumstances. That just means maybe the scope of their available methods to raise capital, like regulation crowdfunding, or maybe regulation D may be closed to them, but yet there are still other avenues open to them as long as they disclose it in a PPM. These other exemptions are still available to them, even though they may have a kind of a checkered past, right? And so that's why it's important to work with a securities attorney, a seasoned securities attorney, that may help you be able to navigate the best way to move forward. Because even the best of people, best of intentions, sometimes they just didn't know any better, and they just found themselves on the wrong side of the tracks, so to speak, right? And so, anyway, hopefully that's helpful to you. I think we're about out of time. Yeah. So again, if you wanted to, cover any of these in particular detail with respect to your PPM, or certainly if you'd like to look at any PPMs, example PPMs, we'd be glad to share. We have a shared Dropbox folder that we send out from time to time, saying, "Hey, here's some example PPMs." I mean, I would not advise you to just try to pick one of those and go copy and paste it, and that'd probably be a bad idea. But yeah, certainly you see that as an example of what we can prepare for you. Obviously, each one is very specifically tailored to your exact specifications and your particular deal, right? So, we also, for members of the forum, we're also, if you want to message us, we can certainly give you introductions to various capital sources. We have a capital source that we've been working with for many of our clients that has over 32,000 32,000 different kinds of investors. We talked about different types of investors on one of our previous forums. Different kinds of accredited investors, family offices, different international investors as well as U.S. investors. And so, if you want to message us, we're glad to set up an appointment and make those introductions, and so you can see what they have available. Now, all these capital sources, they're going to want to see. They're going to see a full disclosure PPM, and that's something that we obviously can prepare for you, and that way you're ready to go. If they say they're ready to go, then you're ready to go. And so, anyway, but yeah, just message us, and we'll be glad to do that. We are excited about next week. I am going to be in Croatia, and we are not going to be doing a session next week, but the following week. But we're still going to be doing 4 sessions a month, and so we'll be talking about PPM disclosures, what is required. We'll be diving into more details in that one, as well as subscription documents, closing investor subscriptions. And then later on in June, we'll be talking about marketing strategies. So those are some things to certainly look forward to. And anyway, it's getting darker here, and so anyway, appreciate you. That's a little better. But yeah, we certainly look forward to having you. We appreciate you being here in the forum, and we'll see you next time. Thank you.